When a police officer looks at you during a traffic stop or any police encounter and says, "Can I see your phone?" almost every person does one of two things. They hand it over, or they hesitate, feel guilty for hesitating, and then hand it over, because the phone is right there. Because saying no feels like hiding something. Because the officer's tone makes the request sound like the kind of thing everyone just does. And because almost nobody has ever been told that handing a police officer your phone is one of the most significant legal acts you can perform in the entire encounter. Here is what almost nobody knows. Your phone is not a pocket. It is not a glove box. It is not a bag the officer spotted on your back seat. Your phone is a window into your entire life, your location history, your communications, your photographs, your financial records, your medical information, your relationships, your movements, your private thoughts. And the Supreme Court of the United States has said specifically and unanimously that handing your phone to a police officer is not the same as handing over any other object during a stop. You have the right to refuse. The Constitution protects that right by name, and exercising it is not suspicious, not obstructive, and not something that can be used as the sole basis for a search. Today, I am going to show you exactly what is happening legally when an officer asks for your phone, what the landmark Supreme Court ruling says about phone searches specifically, what you do the moment the request is made, and the exact words that protect your device, your data, and your rights from the first second of that request. Hit subscribe right now, because this channel exists to give you knowledge that protects you before you are ever in the moment where you need it. Share this with one person before this video ends, someone who would hand over their phone because refusing felt more suspicious than complying. Here is the reality most people are never taught. In 2014, the Supreme Court decided Riley v. California, one of the most important digital privacy cases in American legal history. The case involved a defendant whose phone was searched incident to arrest without a warrant. The court ruled unanimously, 9-0, that police generally cannot search the digital contents of a cell phone seized during an arrest without a warrant. Chief Justice John Roberts, writing for the court, put it plainly. Modern cell phones are not just another technological convenience. They are in fact mini-computers that also happen to have the capacity to be used as a telephone. They could just as easily be called cameras, video players, Rolodexes, calendars, tape recorders, libraries, diaries, albums, televisions, maps, or newspapers. The court said that a search of a phone could reveal far more than a search of a house. In plain English, the Supreme Court recognized that your phone is different from everything else you carry. It holds more private information than your home, and because of that, warrantless searches of its contents are generally unconstitutional. Law enforcement needs a warrant to access your phone's data, not consent. A warrant. This ruling applies to the contents of your phone, the digital information inside it, your texts, your photos, your call history, your apps. All of it. Now here's where the gap lives that most people never see. Riley protects you from a compelled search of your phone's contents. It does not stop an officer from asking. It does not stop an officer from making the request sound routine or mandatory. And it does not stop you from handing your phone over voluntarily, because voluntary consent is a separate legal category entirely. If you hand your phone to an officer without being compelled to, what Riley established as a constitutional protection disappears in that moment. You consented. The warrant requirement the Supreme Court built specifically around your phone is bypassed by your own voluntary action. This is the gap. The protection is among the strongest the court has ever established for any item you carry, and it can be eliminated by a simple misunderstanding about whether you were required to comply with the request. You were not, and now you know that. Here is what the bad way looks like. Officer during a traffic stop asks to see the driver's phone. Driver assumes this is a routine check. Maybe for the registration, maybe to verify something. Hands it over. Officer swipes through recent photos, sees a notification on the screen, asks the driver to unlock the device. Driver unlocks it because the phone is already in the officer's hand, and refusing to unlock feels more suspicious than unlocking. Officer scrolls through messages, sees a conversation that becomes the basis for a new line of investigation, entirely unrelated to the reason for the traffic stop. The driver handed over the most comprehensive record of their private life in a 3-second decision made under the assumption that they did not have a choice. The entire encounter that follows is built on that assumption. Here is what the good way looks like. Officer asks to see the phone. Driver says this immediately and calmly. Officer, I do not consent to a search of my phone. If you have a warrant, I will comply with it. If not, I am invoking my Fourth Amendment right to decline. That is the complete response. 26 words, calm voice, no attitude, no explanation after it. Those words do several things at once. They invoke the Fourth Amendment protection Riley established specifically for phones. They decline consent, which is the only thing standing between the officer and a protected search. They acknowledge the warrant process, which signals that you understand how lawful phone access works, and you are not obstructing it, you are requiring it. And they put everything on the body cam before the device changes hands. Drop a comment right now and tell me, have you ever handed your phone to a police officer during any kind of encounter? Yes or no? I want to know how many people have done this without knowing they had a Supreme Court ruling specifically protecting their right to decline. If you are still here, hit the like button because what comes next is what most people miss. What happens when the officer pushes back, and what you do if the encounter escalates beyond the request. Here is how the follow-ups typically work and how you handle each one. The first follow-up is the simplification move. The officer says, I just want to check something quick. It is not a big deal. You say the same thing again. Officer, I do not consent to a search of my phone. If you have a warrant, I will comply. Then silence. It is always a big deal. The Supreme Court said so by name, 9-0. The second follow-up is the consent reframe. The officer says, I am not searching it, I just want to see it for a second. Physical possession of your phone by an officer, even briefly, is access to your device. Anything visible on the screen, without unlocking, notifications, recent calls, open apps, has been treated in some circumstances as observable without a warrant. You do not hand it over for a second. You say the same response. Then silence. The third follow-up is the compulsion implication. The officer says, I need to see your phone. You say, Officer, unless you have a warrant, I am exercising my Fourth Amendment right to decline. I am not obstructing you. I am requiring the legal process the Supreme Court established for phone access. Then silence. Need is not a legal basis for a warrantless phone search. Riley said so clearly. The fourth follow-up is the arrest or seizure of the phone. If the officer places you under arrest, they may seize your phone as incident to arrest, taking physical possession of the device. But Riley is explicit. Seizing the phone is different from searching it. Even after seizure, they generally need a warrant to access the contents. If your phone is seized, you say, I do not consent to any search of the contents of my phone. I am invoking my Fourth Amendment rights under Riley versus California. That statement goes on the body cam and is your attorney's foundation for a suppression motion if the contents are accessed without a warrant. Let me tell you about Jasmine. Jasmine is 27 years old, lives in Colorado, and was stopped at a sobriety checkpoint. The officer asked for her license and registration, then asked to see her phone, claiming he needed it to verify her insurance. Jasmine handed it over. A notification appeared on the locked screen. The officer asked her to unlock it. She did, because the phone was already in his hands, and she did not know she could say no. The officer saw an open message thread referencing a party she'd attended that evening, and used it to justify additional questioning about her activities. Her attorney reviewed the stop. Insurance verification is not a recognized legal basis for phone access. Jasmine had no obligation to hand it over. Once she did voluntarily and unlocked it voluntarily, the contents were accessible. Her attorney told her one thing clearly. The Riley ruling protected that phone specifically. That protection evaporated the moment she consented. Because consent bypasses the warrant requirement the court built for exactly this situation. Jasmine now knows the 26 words. After this video, so do you. 2 legal foundations make everything in this video exact. Riley versus California from 2014, the Supreme Court held unanimously that law enforcement generally cannot search the digital contents of a cell phone without a warrant. The court recognized that phones contain more private information than a home search could reveal, and established that the warrant requirement applies with full force to phone content searches. This is the strongest digital privacy protection the court has established for any item an individual carries. The Fourth Amendment's protection against unreasonable searches and seizures applies to your phone specifically under Riley. Consent remains the exception that can bypass the warrant requirement, which is exactly why invoking your right to decline is the first and most important step the moment any officer asks to see your device. Here is the complete recap. Your phone is protected by a unanimous Supreme Court ruling that recognized it holds more private information than your home. Police generally need a warrant to search its contents. That protection is bypassed entirely by voluntary consent. The thing standing between the officer and your entire digital life is whether you know you are allowed to say no. The moment an officer asks to see your phone, you say, Officer, I do not consent to a search of my phone. If you have a warrant, I will comply with it. If not, I am invoking my Fourth Amendment right to decline. 26 words, calm, clear, then silence. If the officer rephrases, minimizes, or implies compulsion, you repeat the same response. If your phone is seized incident to arrest, you state clearly that you do not consent to any search of its contents and invoke Riley versus California by name. That statement is on the body cam and is your attorney's foundation. Think about one person in your life right now, someone who would hand over their phone in 3 seconds because refusing felt more suspicious than complying. Share this video with them today, not later, right now. A 9-0 Supreme Court ruling exists specifically to protect that device. The 26 words you just learned are how you use it. Next week, I am covering what happens when a cop knocks on your front door, what they can see, what they can hear, what changes the moment you open it, and the words you say through a closed door that keep every protection you have fully intact. Subscribe so you catch it the day it drops. Hit the like button if Riley versus California just changed how you will handle the next time an officer asks to see your phone. Drop a comment telling me whether you knew before today that the Supreme Court ruled unanimously that your phone is more private than your home. Know your rights. Use them. Stay safe.